knowledgeable experience with this. There's a fairly short lifespan on the metabolism rate of the methamphetamine compound, so that would indicate most likely recent or heavy usage. So, Mr. Mosher, if we assume for a second that she's going to test positive and she does not challenge it any further, what would the state's position be?
Your Honor, I to some extent I would leave that to the court. I'm just concerned if Ms. Cummins is impaired to, and this isn't the first time I've encountered this type of situation. I've taken the same approach. Given the seriousness of the situation, I'm concerned with going forward with sentencing if she is in fact test positive.
Okay. If that's the case, then I most likely will probably agree with the state, because the last thing they'll really want is an individual who ostensibly is under the influence sentencing, and I will probably want her taken into custody until she presents with a clean urine sample, and then secondly, she'll be tested before her next sentencing hearing. So why don't I go off the record? Ms. Premier, you go and talk to your client for a minute while we wait for the officer, and then you let me know what you want to do after having time to consult with your client.
Judge, I have consulted with her. Well, I'll talk to her now. I'll be back in a few minutes. That's fine.
All right, we'll stand in recess. Kansas, we've had proffer. Well, let me get back on the record. Sorry. We are back on the record in State of Kansas versus Jennifer Shanae Cummins. The case number is 20 CR 17. Ms. Premier, I've provided you an opportunity to confer with your client in confidence in regards to the state's request for a pre-sentencing UA. They've at least proffered a good faith basis, and you've at least proffered some disturbing facts. I left the ball in your court. The officer is now present and can provide the court with his testimony. Have you, after discussing with your client, how do you desire to proceed at this point?
Well, Judge, I mean, she will test positive. I don't know that the officer's testimony is needed today. I don't know if he's ever even met her previously, but Judge, I could make arrangements for her to get a drug and alcohol evaluation between now and her next sentencing. It is my understanding from my client that she has been, since her release from jail, she has had long periods of sobriety and then would relapse. She has had two recent deaths. A stepson of hers passed away in June, and then recently a friend of hers committed suicide. So that triggered her usage. She does believe that she can maintain sobriety and doesn't feel the need that she needs to be placed into custody in order to be sober. I will tell the court that she does have 2 young children, which she has custody of, and maintains the home for those children. So my concern is if she does go into custody, or if the court orders her into custody, that this could trigger a whole sink case and it could be placed in DCF custody and just disrupting the whole family.
Where's the natural father at, or the significant other?
So the oldest child, her father is incarcerated somewhere, and then the youngest child, he lives in Wallace County and has weekend visitation.
Mr. Mosher, I'm willing to accept the proffer of Ms. Premier Chavez that her client will test positive for today's purposes. Is that adequate for your purposes, or do you still want the officer to testify?
Your Honor, I would tell you that in the recess I